Gallman, the commission,
Yes. Mr. Gallman, if you would please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir.
Mr. Gallman, the commission has before it your affidavit of complaint, which I respectfully request be made part of the record at this time. The purpose of today's hearing is for the commission to review the qualifications of the candidates to determine whether Judge Bromell Holmes is qualified to be on the Court of Appeals. The commission is not here to relitigate a case, and they do not have the ability to change the result of your case. Mr. Gallman, you've submitted your affidavit, which the commission is reviewing. Is there anything else you wish to testify to, specifically regarding Judge Bromell Holmes' ethics, competency, or character that has not already been covered by the commission?
Yes, and I would begin by stating for a point of clarification, and I'll read my statement very brief, perhaps 3 minutes at most. But I'd like to start with a point of clarification. We completed a psychological evaluation that was completed in December of 2000.
Mr.
Hold on,
Mr. Gallman, my responsibility here.
I understand.
Yeah, well, I don't think you do. The goal here is to provide additional evidence into the record.
And it's important that I establish this for the record.
Okay. All right. Briefly then, if you will, and
now
before,
a brief statement.
well, we'll talk about that. Let's do this one first.
Okay. I want to make sure as a point of clarification, prior to the final divorce order, we completed a psychological evaluation. The guardian that was involved in that case is sitting in this room. That psychological evaluation was not put on the record, and I settled via consent order for 50-50 equal time and agreed in a no-fault divorce to pay $6,888.88 a month. Okay? So a psychological evaluation was completed. It was kept off the record because the plaintiff's attorney did not want that on the record. Subsequently, she got another attorney and filed to take the children away from me, and the judge was unaware of that. So I will grant her the benefit of the doubt. But there was a psychological evaluation that was completed, and in that 362 days and nights, I went to 2 other providers. I was completely exonerated, and I could put that psychological evaluation out on my ex-wife today, and could have put it out at any point in history. That would have hurt my children. And it would not have been in the best interest of my children. So I want to clarify that. And one other point of clarification.
Hold on. It's a weird system we got here, but when I press the button and need your attention, I need your attention so that we can stay focused on what we have to do here. And that is evaluate the candidate as related to the non-statutory and constitutional requirements, qualification requirements. To that end, you, I think, have made clear that there were additional evidentiary factors that mattered and therefore had a consequential effect with respect to your analysis of her satisfaction of those qualifications. So I think you made that point, and now I understand you wanted to make an additional point that's relative to your statement. I'm not going to allow a reading of a statement that has been submitted to the commission already because we have it in the record, and our purpose and our focus is on adding additional information both for the benefit of the commissioners here, but also for the members of the General Assembly who will have to rely on this commission's report in making their decisions with respect to the election of judges and justices. So to that end, if you have additional things that you'd like to add, I'd be happy to hear from them. But again, I want to emphasize that this is not a forum to relitigate the merits of the case. And I empathize with you. I get it. I've been there. I haven't been in your shoes, but I can feel the passion. And so I want to be fair to you and to everybody involved in this process, and would kindly ask you to focus your comments again on the information that we don't have somewhere in a written form.
Thank you, Chairman Caskey. If I may.
Yes, sir, please.
Thank you. The other point of clarification that I would like to make is that the assertion that it could have been objected on the record was not possible, as this occurred at a temporary hearing where no one spoke. The judge took the information, called a recess, came back, and I will start with my statements. I want to make sure that the record reflects that it could not have been objected in a 15-minute temporary hearing. I digress. On September 23rd, 2019, my children were taken from me by Judge Jan Bromell Holmes. They were not just removed from me, far worse. I was forbidden from seeing, speaking, or any form of communication for 362 days and nights. This was beyond court-ordered parental alienation. It was court-ordered erasing of an entire side of a family. In essence, my children's family was erased from their life. Half of their family was erased from their life for an entire year. At the time, my little girl was 10 and my little boy was 9. Up to that point in their life, I had been a constant fixture in their lives. They both lived with me every day for most of their lives. Only after my recent divorce and the 50-50 consent custody agreement did that change. But even after the divorce, my children lived with me half of the time and were able to communicate with me on a daily basis. I'm still baffled at the reasoning for my children being taken from me. As my attorney has addressed, Judge Holmes took my children because she believed I made a complaint against a counselor with South Carolina's LLR. I thought that complaints were supposed to be confidential and statutorily protected. The other reason Judge Holmes took my children from me is because I took my daughter to MUSC to be examined. I found bruises on the interthighs and the crotch area of my daughter on 5 consecutive weeks in a row when she came to me in the summer of 2019. And thank God I had moved into a new home with a swimming pool, and every time she came, I would ask her to get in the swimming pool.
Mr. Chairman, I'm sorry, at some point, and Mr. Gallman knows, I talk to him all the time, he and I agree on a lot of things, but he is at this point relitigating the case, and the other party that he is just accused of abuse is not here to say that that's not true.
I've not accused anyone of abuse, Mr. Rutherford. Never once in the record have I ever pointed the finger.
Hey, one at a time, one at a time.
Don't put on the record I've accused someone of abuse. I have
Mr.
never.
Goldman, Mr. Goldman.
Okay, let's.
One at a time. And, Mr. Rutherford, I've heard your complaint, I've taken notice of that. Mr. Goldman, affording you some latitude here, given the gravity of this moment and the seriousness with which we have to evaluate all of this. But I need you to get to your point of new information for this commission, because we've heard a lot now several times, and I want us to get to the finish line smoothly. So being mindful of Mr. Rutherford's comments with respect to the repetitious nature of some of what you're offering, I just want you to land this plane with us in the next minute or so, okay?
I can land this plane in 3 minutes if I'm not interrupted.
Well, we got about 1 minute, so let's do it that way. After you.
Because of the location of the bruises, I sought counsel from multiple professionals, including my lawyer and a licensed professional counselor. The counselor advised me to take my daughter to MUSC Children's Hospital. MUSC documented the bruises in my daughter's inner thighs, while the MUS social worker and a member of law enforcement made mandatorily statutorily reports to DSS. Judge Holmes accused me of trying to use a false complaint of child abuse to gain an advantage in a custody matter where I already had 50-50 custody. That is absolutely unequivocally untrue. MUSC's pediatric crash team social worker made the mandatory complaint to DSS. I was trying to protect my daughter. I called 2 different professionals prior to taking her to MUSC. Both advised me to do this. How could my attempt to protect my daughter be used to take her away from me? But that is exactly what happened to me. To me, the law utterly failed my children. If Judge Holmes wanted to punish me, there were ways she could do so without hurting my children. I've spent well over $500,000 in the divorce and custody battle trying to establish my children's right to have a dad and to be a dad. And I would spend $10 million more dollars if that's what it took in order for my beautiful, wonderful, precious children to have a father. Before she took my children, I volunteered for everything that my children did. I was the homeroom parent for both of their classes at the time. I chaired the homeroom parents committee. I was the vice president of the PTO. I was a member of the school improvement council. at a local public elementary school. I chaired the school dance committee, and I was coaching my son's 24th youth sports team.
Mr. Gallman? One second, if you would. I've tried several times to help focus the conversation against our mission here. I certainly understand your grievances and your frustrations and your hurt. There's no question that every one of your words is dripping with that emotion and deserves its full and due respect. I would be remiss in my duties, though, if I did not give you one last chance to get us to something that is going to tell us about Judge Bromell Holmes' qualifications for the Court of Appeals. Now, so pause right there. We're going to go to Senator Sabb and ask the Senator if he has a question for me, for you, and what that might be.
Mr. Chairman, I did have a question for the gentleman. What?
Thank you, sir. All right.
If I may,
We have a-
I can finish in 1 minute, if you would.
We're
if I
already at a
could
minute.
finish.
Let's call it 20 seconds, though.
Okay. With all due respect, Chairman Cassidy, I've waited for 4 years. So I'm gonna take my 2 minutes to finish.
Well, let me ask my questions then, if we're gonna go that way.
Well, we're not, Senator Sabb, we're not going to go, I understand your frustration. Our complaint process is very clear. And you have submitted documents, you have submitted a complaint, and we will take those under advisement. I understand that this isn't the forum you maybe hoped it was, but we're giving you time to explain to us where she fails to meet these criteria. You've told us a story that is, story is not the right word for it. You've explained your situation, I think, and brought lucidity to this episode. We're now looking for, again, things that we don't have in the record. Now, admittedly, I don't have your service as a PTO officer in the record, and I appreciate that. But I need to know things that help us and the General Assembly make decisions about the election of judges. So, with respect, if you can get this done in 30 seconds, I'd be happy to hear from you. If you can't do that, then I'm going to ask you to sit down.
Okay, thank you so much. And as I was stating, at the time, I was a partner in a Fortune 400 company, 4 times over a partner, in over 60 branch offices of a firm here in South Carolina. I'm going to end with this, and I'll state 2 things for the record. Removing children via an abrupt emotional cutoff in a 15-minute hearing with no evidence is cruel, it's unjust, it's inhumane, and it's evil. I want you to consider, and this will be my final statement, that for a 9-year-old little boy whose dad was coaching his 24th sports team and a 10-year-old little girl to be removed from their father for 362 days and nights, literally 10% of their life, with no phone call, no text message, no Christmas card, no Happy Thanksgiving, no birthday present, no nothing. It damn near killed me. And it was cruel and unjust. And anyone that does that should not be promoted to the appellate court. With that, I conclude my testimony.
Thank you, Mr. Gallman. Appreciate your time and appreciate you coming here to testify today. Mr. Rutherford?
The person that the LLR complaint was filed against, what was the name of that person?
I don't know that that's relevant
It's in
here.
here. It's in here, and I'll tell you why it's relevant. I just need to
Tell me
know-
what's relevant first before we go down this
Because
conversation.
number 4, on page 2 of 5, the defendant father has filed / made a complaint against the minor child therapist counselor, Roberta Bogle, that have been dismissed. Once a complaint is dismissed with any agency, you are free to talk about it. And so the substance that they have talked about in now 2 testimonies going to this LLR complaint, at that point was dismissed.
Right, but Ms. Rutherford, you're talking about the affidavit of Mr. Player, that's not.
No, sir, I'm talking about the judge's order. This is the judge's order.
Which was submitted with Mr. Player. I think the point stands, and I think the commission can consider your point as in its evaluation on the totality. I don't think that requires a response from you, Mr. Gallman.
Chairman Caskey, if I may respond to his statement.
I don't think it's necessary.
It is to establish the record.
Sir, I respect
It absolutely is.
Mr.
For the
Gallman,
record-
Mr. Gallman, one at a time, one at a time.
Okay, well, please.
Hold on. What we're gonna do is I'm gonna give you just the last little bit here. We've got other folks that wanna be heard, okay? But I don't think the issue of whether or not the legal propriety of the inclusion or not inclusion of this LLR complaint is one that we need to arrive at a conclusion on here. I understand there's differences of opinion here. That's not our chore here. Our task is to evaluate the candidate. So if you have something else you wanna say, I'll hear you.
One sentence,
All right, shoot.
please. Thank you. To Mr. Rutherford's point, just Representative Rutherford's point, I gave no documents to LLR, not one single document. Never have I given a document to LLR. As it relates to Roberto Bogle, I cannot talk about it because I signed an agreement that I could not talk about it, but we settled a lawsuit. That will stand on its own merit.
Thank you, sir. Again, appreciate your time. Thank you for being here. That's all, sir.
Thank you.
Thank you.